Welcome to the Brigham Young University Family History Library webinar series. Feel free to use the chat box for any questions. If we are unable to get to them during the presentation, they will be answered at the end. My name is Maddie Acey. I will be your host for this webinar. Today we will be pleased to hear from James Tanner, who will be giving a presentation titled Land and Property Ownership for Genealogist. James Tanner has a bachelor's degree in Spanish and a master's degree in linguistics from the University of Utah. He received a Juris Doctor degree in law at Arizona State University. He served for 2 years as an intelligence analyst for the U.S. Army and 39 years as an Arizona trial attorney. He has previously owned a retail computer business and an Apple Macintosh software company. James has over 32 years experience in genealogical research and is an avid blogger of Genealogy's Star blog and Rejoice and Be Exceeding Glad. He served for 10 years as a missionary at the Mesa, Arizona Family Search Library and is currently serving at the BYU Family History Library. He has presented at expos and conferences around the U.S. and Canada. James has 7 children and 33 grandchildren.
Howdy, this is James Tanner. We're here with the Brigham Young University Family History Library webinars. This webinar series is being recorded and will be available on YouTube through the BYU Family History Library YouTube channel. You might want to subscribe to the channel. In that way, YouTube will send you some email notifications of when new webinars are posted. We're going to talk today about land and property ownership for genealogists. Kind of starting out with a picture in the background there, and the picture is represents the ceremony of homage, wherein the vassal knelt before the Lord and acknowledged himself to be his man and swore fealty to him. Now, one of the things that we're going to come up with in this particular presentation is a lot of language that may sound like words that are a little bit foreign, and they are, but they're just old. And this goes back to 1066, back when William the Conqueror came across the English Channel and decided to take over England. So we're going to talk about some of that history kind of briefly, and pick up some of the land terms, and then we'll focus on the various types of deeds and land conveyances that are around and current today. And when we say current, we mean like the last 200 years. If we're talking about old stuff, we're talking about stuff that goes back at least 1,000 years or more. So we're not in law and in land ownership, things change really slowly. You can basically see some of the exact same wording and some of the same documents that were used 1,000 years ago that are still part of people's ownership chain of title, actually. So they have to know all this stuff that goes back to understand how they got to be the owners of what they have today. Okay, so first of all, for land and property law, we need to understand that there's a global perspective. One of the developments of civilization over the last few thousand years has been the concept of private property ownership. And that doesn't really go back very far in our world's history. It wasn't too many years ago that nobody owned anything except the king. And so we're basically going to have to go back and understand the transmission of ownership from the royalty to the common person. A couple of sayings that we'd like to emphasize. One is that a thorough understanding of the modern land law is impossible without a knowledge of its historical background. Let's focus on that statement. This comes from a book that I used in law school. Called Land and Property Law, and usually they're referred to by their author, but we'll just call it that. First of all, it says that a thorough understanding of modern land law is impossible, and the word is impossible. It doesn't mean just difficult. It means you can't understand how modern land law works until you know how it worked historically. That's just the answer to the question. And genealogists who resist getting into history and resist looking into the background and historical are really floundering around out there without any basis for understanding what they're doing. Then there's another statement here, and this was from Justice Oliver Wendell Holmes in a case when before he was on the Supreme Court, and it says, "A page of history is worth a volume of logic." No matter how logical you think you are and how much you search for logic in land law, there is no logic. It's history. It's what happened. It's not what we think it should be or how we think it ought to work. It just is there. And this is one of the hardest things, by the way. When I was in law school, I had a little bit of an advantage. I had been working in libraries in undergraduate and graduate school. I worked at the library in the University of Utah. I went to law school at Arizona State University, and so before school started, I was in Phoenix, just getting out of the Army, and so I needed a job, and I knew I was going to go to law school, so I went to the library at the ASU Law Library at the time and said, "Here's what I've done at the University of Utah. How about a job?" They said, "You're hired." So so I had actually been working at the university at the reference desk in the ASU Law Library uh, for about 2.5 months or 3 months before school started, before the first year law students showed up for classes. And the advantage was that I was sitting there in the library after each class when the semester started. And what happened in each class was there was this huge mob of students who would come running into the library, literally at top speed, trying to be the first one to grab the dictionaries and try to figure out what the professors had just said to them. Because the language was so different than what most people were used to, that you really need to have a translation sometimes into different terms so you understand what they're talking about. So we'll try to simplify some of these terms as we go through some of the history of land and in property, land and property, deeds, and all of the other things associated, including probate actions, which have to do with land and property, and some of the other court actions that people became involved in and our ancestors were involved in. All have to deal with the same kind of this language. And the further you go back in time, more of these terms become current in the documents that you'll have to read. And it's kind of tragic what you see with people who have not gone through the historical searches and know what they're talking about, because they'll pick up a deed or they'll pick up some kind of a document that had to do with the court action on the property, and they'll get who bought the property and who sold the property exactly opposite. In other words, they can't figure out who bought and sold the property. So we're going to see if we can clarify a few of those terms. There's nothing we can really do in an hour that will turn you into a bona fide historical genealogist, but we'll get you started on the process. And my statement is that doing genealogical research without a knowledge of history is like wandering around in a forest without a compass. You really don't know where you are, and you really don't know what you found once you get there, because you are unaware of the historical context of what you're dealing with. And my understanding, my observations over the past few years, many years, 30 plus years of working with genealogists, is that they're usually in a fog because of a lack of knowledge and understanding of the terminology and the kind of information that they're dealing with. So let's start. First of all, we need to understand that U.S. land law is based on English law primarily. Now, America was colonized by various European powers. Most of the southern part of the country and the western part was settled by Spanish-speaking people from Spain. Most of the northern part of the country in the east was settled by English-speaking country. Parts of the country in Canada and down the Mississippi River and the central part of the America was settled by French-speaking people. So we have three prominent languages and two prominent law systems. English law is based on precedents. It's called common law. And what that means is that the English observe the rule that the law evolves as court cases are decided. So in determining the outcome of any controversy, the English law looks to case law, meaning the decisions of judges on that particular issue in the past. So the cumulative decisions of all the judges are what make up the bulk of the English law. Overlaid on top of English law is what we call statutory law. That's law passed by the legislature. So some parts of land law are governed by case law, meaning the precedents, what we call stare decisis, or the case rules that, or the decision rules, that the decision is what, of the courts, is what we have to look to make a decision as to what the law is, what the way that any given case would be decided. So what attorneys do, and basically, is they internalize a great deal of law. People used to come to me and ask me, how many laws have you had to memorize? And I'd say, I would never memorize a law because it would change, and then I'd be stuck with my memory, and I don't ever try to memorize anything because that was counterproductive. I would always check to see what it was today as opposed to what it might have been yesterday. But case law is different. Case law is cumulative, and then it's just a matter of whatever happens in that particular case. Well, this is English law in kind of a nutshell. Two different types of ways of looking. The French and the Spanish and France and Spain worked on what we call civil law. In that case, the law was codified, meaning it was written down in statutory form. And in order to decide a case in Spain or France, the judges don't look to what they did yesterday or what they did years ago or what their predecessors may have done years ago. They simply look at what the law says today and make their decision based on the statutes. Now, neither the English law nor the civil law are pure in the sense that it works that way all the time. In English law, if you violate a criminal law, for example, it doesn't matter how many cases there are that decide that criminal law. The judge has still got to consider about whether you did something that was contrary to that particular criminal law. But in civil law, it's a little bit different, and then it's a little bit more flexible. And most of the time, people would want to have a specific prediction about the outcome of a case. I spent most of my 39 years being a trial attorney, taking case after case after case to trial in courts. Sometimes they were disposed of before. Most of the time, they never made it to trial, but we'd have a significant number of trials every year. And they would always ask me, my clients would always ask, well, how is this going to come out? And I would say, who knows? I said, whether, depends on what you wear to court that day. And they go, oh, come on. I go, nah, really, it's come down to that in some cases. So don't put past what minor little things can create law. But cumulatively, over time, English common law has turned out to be one of the wisest and most well thought out and reasoned systems of law that has ever been evolved in the world. The reason why the American legal system works is because we have based it on English law. And that way, there's no way, for example, that a new legislature, a new president of the United States is going to be able to change the common law in the United States. It's cumulative, and there's nothing they can do about it. They can try to affect it by putting in new Supreme Court justices. They might try to change a few things that way, but um, inevitably the law comes back to the consensus of all the judges who have decided all the cases that have been decided, all the thousands and thousands, perhaps millions of cases that have been decided in the United States. Okay, so now we're back to William the Conqueror in 1066. You may not be aware of English history very much, but if you're going to be a genealogist and if you have English ancestors, then you need to know that. Now, we're going to use English law here because we're talking about land law in the United States, but I would point out at this juncture that it's important to you, to anyone who is doing genealogical research, and once they have left the United States, which they will do inevitably, you will realize, of course, everyone in the United States is an immigrant. It's just a time frame that determines whether they were an immigrant or not, when they were an immigrant. So it doesn't even matter even if you claim, well, I'm a Native American, and my answer is, yeah. When were you born? Yeah. Well, when was your father born? Where was he? Where was he? Go back, go back, go back, go back. Okay. Eventually, your father was that great, 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 great grandfather back however many generations, even if it's a few hundred generations, came from somebody else, someplace else, according to modern theories. The humans originated outside of the New World, and we're all immigrants. So at some category, we're all in the same boat as far as we didn't come over in the same boat, but we all are in the same category as far as being immigrants in the country. Now, what happened when William the Conqueror brought his French-speaking troops across well, strictly speaking, they didn't speak what we call French, but they did speak a language that was closely associated with that. When they came across the Channel and invaded England and won, they began to establish what we call feudalism. And what does feudalism mean? It means that the king confiscated the subjected lands and gave interest in the land to his supporters or vassals. Okay, so the king owned all the land. And when he came over, when William the Conqueror came over, he claimed everything in England. So he said, I own it all, personally, as king. And now, since I'm such a good guy, I am going to give all my generals, all my knights and supporters and my followers, I'm going to give them pieces of land that they can have, possess in a sense, but they're not ever going to own it. No matter what they do, they're never going to own that land because I own it all. And so they're basically based on my good graces. So if I don't like them for some reason, I can kick them off their land. Okay, so that's kind of the idea there. And so all these vassals, or people who were beholden to the king, held the land as tenants. So they didn't own it. Nobody owned it except the king. And the grant of land was always burdened by an obligation of service back to the king. It's called servitia debita. And that was that service is owed. And so there was different kinds of ownership, and there were different services that had to be, that were imposed on each of the land grants, depending on how the politics of the day and who the king liked and who he didn't like. So it was just a matter of personal grants from the king. And the person who held the land directly under the king was called the tenant in chief. So they're the top guys. And they came out as princes, dukes, all sorts of things, depending on the English royalty organization of the time. They, in turn, could then give land to their vassals, to the people that they thought were worth giving land to. But then neither of them, neither the ones given the land by the tenants, vassals, the tenants in chief, or the tenant in chief owned the land. The king still owned all the land. But when they gave the land, then there was a duty or obligation or burden that went on the land to them individually. Okay, so they created this whole thing. Now, if you're a good addicted television watcher and you've watched Downton Abbey through all of its seasons, you probably have gotten the idea that there's still some of this left over in England today. The answer is yes. Only the interesting thing is there's something of this left over in the United States today too, because we started out with English law. So we have the same interests. Okay, so now we're talking about tenants in chief. And by the way, the pictures that I have here are from Bayeux Tapestry, which is a giant tapestry that was woven showing the history of William the Conqueror and the other kings that were following him and their vassals and all of this transaction. So it's kind of a large pictorial cartoon history of the conquest of England. So then the tenants in chief made allotments, and we're using all these terms. Allotment is a piece of land to the knights, and then they became tenants of their lords. So the tenants in chief were beholden to the king, and their knights were beholden to the tenants in chief. Now there's some interesting things because there's some of the history of England that people know about from the popular historical records and all of the movies and books and fiction books and things that have been written. And we go back to kings like King Arthur, and we go back to other kings back in the early dark, before the Middle Ages, even back into the 800, 900 AD type people. This system of land ownership was imposed after 1066. When they talk about knights, knights is a kind of a general term meaning somebody who owes you a debt or that's your guy, is part of your organization. But this is entirely different because this whole system here was based on land, on who had the right to occupy, use, and obtain the benefits of the land. And so that was how this all arose. And this all was essentially created and solidified, and the word we would use would be codified into a formal system beginning with William the Conqueror. But directly or indirectly, the king owned all the land. So there wasn't any question about who owned what. Now, the land was transferred by a process called enfeoffment. A person was enfeoffed with the land. And basically, when they became a tenant, and they were occupying the property, they were said to be seized of the property. And this is and what they would do to create the seized, or to be seasoned of the property, or seized of the property, you had to be enfeoffed, and the enfeoffment involved what was called a livery of season. They actually transferred the property right to the occupation of the property physically. The owner of not the owner, but the lord of the property, whoever had the tenancy from the king, when he enfeoffed the person who was becoming seized with the property, would reach down and pick up a handful of dirt and hand it to him. So it was a physical transfer, symbolically, but a physical transfer. Okay, so what that did was it invested a person with possession of a freehold estate. Now, the term freehold estate is a little bit misleading. It was neither free, it was an estate, but it wasn't free. And what we mean by freehold was that the person then gained control over the property. Even though they were subject to the Lord, they were also they also had certain rights of their own at that point. First of all, land could be subject, all the land from the king was subject to military tenure. What that meant was that the people who obtained ownership through this tenancy process had to provide soldiers to the king or to their lord. These were the knights. And so when the king needed people to fight a war, he simply went to his knights and said, we need this many men. And they would go to their land holdings and they would say, we need this many men. And it wasn't a question of draft or being or asking for permission or whatever. They had the absolute right to go in and take the people and put them in the army. So it wasn't a question of voluntariness at all. Okay. In addition, they could also, or some pieces of property did not have military tenure. Some of them had feudal tenure, which meant that for services, that means that they would have to provide services to the king. That would be food. That would be providing him with objects, with furniture, anything, any made type of thing that could be manufactured or created could have been levied as a service to the king. So if you're a Downton Abbey fan and you get into the long discussions that they had about how they were going to deal with the property and all of the tenants on the property, the answer was they owned all the property, and none of those people, even if they'd lived there for 200 or 300 years and their families before them, had any rights to be there. They could simply be removed at the whatever the lord of the manor wanted to do with that particular property. And then these are all called serjeanty tenures. So their serjeanty tenures are the different kinds of requirements or duties that were imposed on the land as a result of the fact that they'd been given the land by the lord, who would then got it from the knight, who got it from the king. And as I mentioned, the tenancy had to be created by season, and it's not S-E-A-S-O-N, it's S-E-I-S-I-N. And this is actual ownership. It's taking actual physical possession of the property. So possession had to be made under a claim of a freehold estate. In other words, you could only possess the property if you'd been given the right to buy the ultimately from the king down through the line of people who had obtained possessory rights under this particular legal system. Now, this may sound a little bit foreign. In other words, you at this point, as I start to say this, and I could sit here and try translating more into common language, you're probably saying, well, what does this have to do with what we do today? Well, the answer is, this is the same way we hold property today. We don't use some of the same terms, but ultimately, this is exactly how we all get the same property. And it's interesting that we think we own stuff. It's always after you get into understanding how all this works, you begin to realize that land and property ownership is a lot more complicated than you thought it was when you just went and bought a house. If you thought it was difficult to buy a house in the United States today, you are only looking at about what they call the tip of the iceberg. You're only looking at the small amount of information that you really need to know to understand that. So what's the difference between possession and ownership? Well, ownership is what the king had. He had the right to do whatever he wanted to with the property. Possession means that they had the right to use the property under certain terms and certain restrictions. And usually for a term of years, meaning there was a time period involved, and there were only certain things that they could actually physically do with the property. Perhaps you have watched a few movies or read a book about Robin Hood. Well, if you get into that, what the concept there was that the Robin Hood and his band of outlaws were actually trying to possess property that they had no right to, and they were also trying to use it in a way which was contrary to what the Lord of the Manor wanted to use it. Uh, I mean, it makes good reading because it sounds like they're the good guys and the King John's and the Sheriff of Nottingham are the bad guys. Um, the answer is they were only the people in power, and they weren't necessarily. They could be bad. I mean, depending on which movie you've watched. But in reality, they were just doing nothing more than preserving and operating their property, which they owned and which the people that were rebelling in that case did not own. And the whole thing here is made obsolete, meaning that your claim to possession or the claim to the possession of the property through the freehold estates that were granted down through this chain of title from the king are made null and void or made obsolete by the actions of ejectment or for adverse possession. What does that mean? Well, ejectment is a term meaning to gain possession of the real property. So if I own a piece of property and you're on the property and you fail to pay or maintain the interests that I have set down as preconditions for your possession, then I have a right to remove you from the property. And that right to remove you in a general sense is called a right of ejectment. Um, there's a lot of that. Then we have another issue, which is adverse possession. And that means that if you move onto my property without permission, and I can prove that I own the property and or that I have control of it through my ownership through the king or my estates through the king, then I can have you removed. And that is an action for adverse possession. These are current actions that you would have brought very frequently in the courts today. I am handled hundreds of cases of adverse possession and ejectment over the years. This was one of my major areas of practice in being an attorney. Now, the service, which is the duties owed to the king, military service or other services that had to be provided, food, goods of any kind that were payable to the king and up through the line to the king, attached to the land, and they run with the land. When they say they run with the land, it means that uh, even if the land changes possession, even if the person who is possessing the land changes, the duty does not. The duty is part of the land itself, not an obligation of any one owner or any one possessor of the property. And this is something that we have very commonly now in the United States. All of this attachment, you might live in or know someone who lives in what we now call a homeowners association or a condominium association. And both of those date back to this time when you had the ability to create obligations that ran with the land. So if you buy a piece of property in a homeowners association today, we have what are called deed restrictions, which run with the land and create obligations and duties on your part. In other words, you may have to pay the homeowners association dues because someone recorded a deed 10 or 15 or 20 or 50 years ago, creating that obligation as part of your land ownership in that area. And that's what this all comes from, back to William the Conqueror. So if you're upset with your homeowners association, you can start getting upset with the king because he's the one that started it. Okay, now, kind of moving along, the law began to evolve. It's not, we don't quite have the same king-operated feudal system that they had 1,000 years or more ago. Where it began to change and where they began to have some difference, where they treated it differently, was what's called the Doomsday Survey. Now, there's lots of speculations as to why it was called the Doomsday. It had to do with taxes, and some people, I guess, thought that was the end of the world, because they called it the Doomsday. But the Doomsday Survey was done as a taxing survey by William, and he put out a tax called the Dangold, or Dangeld, and it was a direct tax on the property. And um, it gives us this went out, and they did this survey to see who owned all the property and how much they had to pay to the king in taxes. And this is the oldest record we have of feudal tenures, going back to 1086 AD. So this is where it all starts, where we get our oldest land records. And by the way, it's still in existence. They're still paying this in England. And you can read all of this in of these records. The Doomsday Book records are on a program called opendoomsday.org. They're also on familysearch.org. So if you want to see what the original documents look like and who owned it and all the language back in 1086, then you can actually read that. What was the results of all this? Okay, now we've got all this feudal system of transferring land ownership and title by tenure to land use and possession, excuse me, by tenure. And the results of this is that people could not easily move from one place to another. Okay, so how long did this last? There have been some people who have done some studies of vital records, old parish records and other records in England, and statistically figured out how far people could move in those days. And what they did was they looked at all the birth, marriage, and death records, and they compiled lists of all the people and all their parents, and they went back, and they did this survey across the country of England. And what they determined was that until around 1850, in the Industrial Revolution, almost uniformly, people did not move more than 6 miles from where they were born. So people, if you drew a circle around each person, on the average, those people never left more than a 6-mile circle from where they were born. They married people within the circle. They died, they were buried in that same 6-mile circle. Okay, so yeah. And so when you start going back in your genealogy and people start saying back in the 1700s and 1600s, they say, well, this person married this person in this county, and then they married this, and their children were born in this county, and the answer is that's all baloney, because there's no way in the world these people moved. They were owned. They had no rights. They didn't own the property. Well, how do they live? If they left their tenancy, they died. They would starve to death because they didn't have any rights, any place to go anyplace. We would call those people serfs. That's a polite way of saying they were slaves. So this is the way they lived. Now, in the United States today, land is still held subject to taxes and government claims. Okay. So no matter how much you want to justify how the world works, you're still going back to the fact that we have what is called sovereignty. We have governmental sovereignty. So that means we have substituted the United States government for the king. And you say, well, I own my land. And my answer is, stop paying taxes. How long would you own your land? Not very long, because pretty soon they would sell your land for the taxes. And they have a right to do that. I own my land. What if they decide to put a freeway through your land? What chance have you got? Zero, because they own the land. They can bring a claim for governmental sovereignty, and they can then move you off of your property and put in whatever they want to. And so these are that's the reality. The reality of it is that all of the land system in our country dates back to the same system and is still the one that's in effect today. And we live in a kind of a veneer, a coating of what we might call private land ownership. But in other words, in reality, the ownership is still with the government ultimately, and nobody else really owns the property. Okay, so here we have two things. We have tax liens and we have eminent domain. Uh, if you don't pay your taxes, you'll lose your property. If you are in the way of where the government wants to expand, they have the right of what's called eminent domain, which is another way of saying the government owns all the land. Now, we're going to go back to another concept here that helps us to understand how we transfer property today, and that is the concept of free and unfree tenure. If the services were definite and certain and ran with the land, or they were services subject to the will of the Lord. Okay, so here's the difference. A free tenure was where services were definite and certain and ran with the land. So if there was an imposition of military obligation and you were supposed to provide so many troops, that was something that ran with the land. It really had nothing to do with the needs or the will of the Lord of the manor. But if the services were subject to the will of the Lord, in other words, they could impose how much grain they needed that year or how much they were going to take in livestock or whatever, then those services were called unfree tenure. You weren't free to use the land. You were subject to whatever the Lord of the manor, the owner of that, under the king of that land was there. Now, all the lands in the American colonies were held in tenure. So everything that dates back in land ownership dates back to this concept of whether or not there were things that ran with the land, obligations that ran with the land, or obligations that were imposed by what we would today call by contract. Okay, so here we go with free tenure. The first type of free tenure was tenure by night service, and that was typical with an obligation to provide military service. And secondly, you claim it by sergeantry, and that was an obligation to perform a service definite to a time and a place. Okay, so they had to provide sergeantry, for example, once again, going to the Downton Abbey analogy, is when they had to appear at a specific function and provide certain dinner or support for a function that was an obligation on their part rather than something that they could avoid. So you'll get a lot of discussion in the Downton Abbey series about, do they have to do this or do they don't have to do this? Is this, and then when they come down and say, no, this absolutely has to be done, it's because we owe it. It's our obligation. Well, that's because they're under sergeantry. They have an obligation that runs with their land to perform duties, services to their overlord and ultimately to the king. And then we have Frankelmein. Frankelmein is land or alms that are given to the church, and the church is kind of outside of this whole system, and they own their land free of the claims of the tenure. So here's one of the things that could happen during this period of time. For example, if you've read enough of these old stories, you know that if somebody had a problem with a knight or one of the royalty, and they were going to get killed because they'd committed some act that the king or somebody didn't like, then all they had to do was race madly across the countryside and get to the church If they could get inside the church, they were immune from any actions by the the king or the knights. Okay, well, that's where this sort of came from, that the land itself for the church was a Frankelmine, and they were separate from the other lands and obligations of the property. So they were kind of like free, home free base for the rest, for the countries. And now we have the last one, which is really the most important one from our understanding. It's called free and common suckage. And those were monetary or agricultural obligations that were imposed on the property. Once again, the word free is kind of a misapplication here if you're thinking that the land was free, like land of the brave and free and all that kind of stuff. Well, that's kind of didn't work in this way. Okay, so what's an unfree tenure? Well, an unfree tenure is serviced by the servile class called villeins or serfs. And so if you were under an unfree tenure, meaning you were under the will of the lord of the manor, you were at his disposal. If he wanted you to move, you were gone. If you wanted to starve to death, you starved to death. Now, in actual history, this happened in England, in early days in Ireland, in Northern Ireland. The English came in and conquered all the land and imposed a tenure on it. And once they've imposed the tenure on it, the people who were living there were essentially serfs. And so what happened at that point was that the English decided that they didn't want the Irish there, so they kicked all the Irish out and put in Scottish hired people from Scotland who came over to work the land for them. And the Irish who got kicked off the land got on boats and came to America. So we have a lot of Irish ancestors of our people who were kicked out of the land because of this concept of unfree tenure. And they had no rights as against the lord of the manor, period, none. So just absolute control. We call them serfs, polite way of saying slaves. Although they were not slaves in the sense of ownership, it was more practical than that. It was, if you leave, you'll die because you'll starve to death. Because if you're a serf and you try to go someplace else, you don't go someplace else and get hired as a serf. You're a serf because you're owned by and you're part of the land of the manor. So if you try to leave, no one else, all they do is throw you in jail. They're not going to do anything with you. And everything was then. So when did villeins become free men? That's the issue here. How did they do that? Because first of all, they became landowners under free and common suckage. That meant they could, or socage. You know, you can read, what happens with these words is that the attorneys learn one pronunciation, and when you go back to what it was really like with the old French words, or mostly French words, it was completely different. But anyway, so we have common ways of saying all this stuff. Sometimes there's differences in the way that people say it. And sometimes some attorneys will pretend they know a whole bunch and they'll say it a different way and everybody will try to do it. You know, it's kind of weird, but that's what happens with this stuff. But we're talking about the same thing. So this is how they became free men, not freehold in the sense of the vassals, but actually had some rights. And first of all, it was 1290 when they called what they called the Statute Quia Emptores, which was the right of every free man to alienate without paying a fine to his lord. Okay, so for the first time, if you owned the property by 1290, you could actually sell it without paying a fine. So that, in a sense, created what we today think of as land ownership. Now, here's the bad part. We didn't get rid of the fines. In the United States, we kept them. And what do we call them? We call them taxes. So no matter what you do, you got to pay your real estate taxes. And if you've purchased a piece of property lately and you've gone through settlement procedures, at the end, you'll know that you pay the taxes up to the date of the sale, and then the new owner pays the taxes after they bought the property. Okay, folks, we still paying the fines to the lords. So we didn't get out of anything. Now, what happened if you didn't do all this? So if your land, if you couldn't inherit the land, in other words, the big deal in Downton Abbey was that there was no male heir to the property. And so they were going to lose the property. Why were they going to lose the property? Well, because it would escheat back to the next person up in line. So it was only kept as long as they could maintain the tenure. And so the failure of the heirship was the big deal. But now it turned in that the failure to pay the purchase price was the big deal. So if you failed to pay the price of the property, for instance, under a contract, then the owner of the property, the seller of the property, can go into court and he can get you to get the property back. And you lose all the money you paid for the property so far through the contract. Now, escheat was also a failure of heirship in the United States, and we still have this. If you do not have a will, or even if you do, and none of the people who are your heirs are available, and in most cases it's children, parents, children, siblings, the children of the siblings, nieces and nephews. In some states it goes out 3 and 4 levels, out and down, and any of those people could be the heirs. In failure of all of those heirs, then in the United States, the property escheats to the government. So the government gets it because there's a failure of heirs. Now, estate planning attorneys in the United States use this as a bugaboo. What they will do is they'll come in and say, oh, if you don't make your estate plan, then everything goes back to the state, which is absolutely false. But that's fine because the laws in the United States provide for heirship. It's just if you don't happen to agree with that, then you've got to do a will and estate planning. Okay, anyway, we won't get into that whole long discussion. Okay, so now we have, after this particular time in 1200s, we have freehold estates, meaning that they could hold the land in what's called fee simple. That means it's an infinite duration. It passes to the heirs. So then it just goes on for time and time and time and time. Or you also got another type of estate, which was called a life estate, which was an estate for years of a finite duration. Okay, so there's two ways that developed where people could hold property apart. Now, do they hold it? Do they still had the obligations of service, depending on the type of service? So here in the United States, for example, if you understand how the law developed when we got the United States Constitution, the people who wrote the Constitution and created the government, the United States of American government, the federal government, understood these principles, and so they didn't really change anything. All they did was switch from the king owning it to the government owning it. So we still owe military service. They impose a draft. We still owe taxes. We still can buy property and people can inherit it. If we have no heirs, then it still escheats to the government. And if we have a life estate, that means we only get the property for a certain number of years, usually the death of the grantee, of the person who got the property. Okay, so here's a fee simple. It's called the maximum legal ownership, the greatest possible aggregate of rights, powers, privileges, and immunities which a person may have in land. That does not mean that they don't have to pay taxes. It does not mean any of the other stuff, but it is the largest evidence of ownership that you can have. Next, you have what's called a fee simple determinable. And in this case, whoever sold the land sold it with conditions. And they said that the ownership expires or reverts to the seller upon the happening or the non-happening of an event. Now, here's what happens, and we'll use good old legal uh, hypothetical terminology here. We'll call the seller John Doe. So John Doe sells the property to Richard Roe on the condition that it would revert to John Doe, the seller, if the property was used for any other purpose but a church. Okay, so Roe uses the property for the church. Eventually, at some point in time, uh, the church falls into disrepair, is destroyed, and it's no longer being used. The heirs of the original owner, John Doe, come and they sue under the fee simple determinable and claim that they own the property because there's no church on it, and they get the property. That's a fee simple determinable. Okay, now that there's estate and fee tail, well, that sounds interesting. Basically, an estate of inheritance limited to the heirs of the body of the donee. Now, this is illegal someplace. It's been laws have been passed to modify this. This was very, very clear in England, and this is and it still is in a force and effect in some places. But basically, if the person didn't have any children who were their children, meaning heirs of the body, then that the tail was broken, the fee tail was broken, and the estate reverted back to the ownership of the person. So it came from the term, the tail part of it comes from the term taliatum from in Latin, and it's limited to lineal descendants of the donee. So um, if they tried to will this to someone outside of the family, outside of one of their children, then that didn't work. That was invalid. Okay. Now we have what are called life estates. So life estate is an estate that's given for a term of years. It's created by a deed or by a will. It's common way to provide for ownership. Let's say, for example, your parent is getting very elderly. They want to avoid the incidence of ownership of the property to some extent, but they want to keep and maintain ownership as long as they're alive, and they want a way to transfer the property before they die. Well, they can give a deed to a son or a daughter or anyone who was related and reserve a life estate, which means that they then can live on the property and own it absolutely during their lifetime. As soon as they die, the instance they're dead, the property goes to the person designated. There's no deed that needs to pass. Most of the time in the United States, they'll require some kind of evidence of the transfer. It's a very common estate planning device now in the United States, a way to get rid of property out of the estate that might be taxed to the estate. It can become very, very complicated. I would guess that there's a huge body of law of litigation that's occurred over life estates. Now we have lots of what are called non-freehold estates. Those are estates for years. An estate for years is, we'd call it the lease term or rental agreement term. So if you, first of all, you have what are called periodic estates, and a periodic estate is a renewable lease. So if you have a lease on a piece of property, you decide to rent a house, and you get into a periodic estate, meaning the lease automatically renews unless there's some notice from the landlord that they want you out in a certain period of time, then if you can have what's called a month-to-month tenancy. Every month your rent, you pay the rent, you get to stay there, but if the landlord wants to move you out, they just have to give you notice and you have to leave. So those are the kinds of things that we've inherited from a non-freehold estate. And we have what's called an estate at will, and that is another term for a month-to-month tenancy. So periodic estates, technically a month-to-month tenancy is a periodic estate, but we have now begun calling it a month-to-month tenancy. Um, by law, by statutory law in the United States, most oral leases are limited in duration, meaning if I tell you you can live in my apartment and we don't have any kind of written agreement, then there usually is a procedure for terminating that that particular kind of lease. And I might mention that modern landlord-tenant law is very, very complex. It gets more complex every year. Uh, the legislatures around the country, there's a uniform landlord-tenant act for the United States, but it isn't. It's more observed. It's the most uniform law that there is, and every state has their, oh, we're going to help the tenants out, and oh, we're going to perturb the rights of the landlords. And so there's always new laws being passed almost every legislature that has to do with this area. Now we have a kind of a narrow area of the law called easements, and easements are the right to use a piece of property for a particular purpose. And most easements we think of are the rights to cross a parcel of land. So if you have a road and you need access across someone else's property, and you would have to get what's called a grant of an easement. You'd have to be given the right to use that as a road. You can use it for any other purpose. All you do is use it to go across the property. You don't own the land, you just own the easement to the land. But they can be bought and sold just like any other piece of property. And unless they're specifically limited by the terms of the easement. If, for example, I might give someone who I liked an easement, and then I'd say, well, yeah, but I don't want to have this be permanent because if somebody else has that right to come across my land, I want to be able to stop it. So I would put an end on it. And then there's a thing called an easement by prescription. It's not prescription, it's proscription. And prescription means that I can force you to give me an easement if I don't have any other way of getting to my property. That's usually the way it works. They're very difficult, by the way, very, very difficult to obtain. You got to prove all sorts of things. And most people just can't prove that they don't have some other way of getting into their property. Not just what's convenient, it's got to be absolute. You've got to say, it's inconvenient for me to drive around the block to get into my house. And they'll say, yeah. But if you say, no matter if I drive around the block, I still can't get into my house, then that's an argument for easement by prescription. Okay, so we have an assignment versus a sublease. When you assign, both can be prevented, by the way. So a lease can be, they can say this lease can neither be assigned nor can you sublease the property to anyone. That means you can't turn around and rent it to somebody else or assign your lease to someone else without permission of the landlord, of the owner of the property. And an assignment is a complete transfer. That means that I'm going to sign my lease to you. Now, we're here at Brigham Young University, and the students, many of whom lease apartments south of our campus in a huge area that's full of apartments, and assignments of leases are very common. Somebody will buy out someone else's lease. Sublease is where you but the problem here with a sublease is on an assignment, the owner acknowledges the transfer. On a sublease, they may or may not acknowledge the transfer, but the person who does the sublease is still responsible for all the terms of the lease. So if you give someone a sublease to your property, you still are liable if they mess the property up. Now we're talking a little bit about future interests. Reversionary interests occur on the happening of a condition. I can sell this property on the condition that it's mentioned earlier, that it be maintained as a church, or that a school, or that it's maintained for charitable purposes, or that it's maintained for whatever reason. And then the reversion is if the property comes back to me, if there's a violation of the conditions of the reversion. And a reverter is just gives you the property back. Fee simple, determinable. The reverter is the condition. The reverter could be anything. Reverter could be that it stopped being held by English-speaking people. I mean, some of them could be violations of some other laws and whatever, but uh, technically there's no limit on what you could write into a deed to be a reverter. One last couple of things at the end here. Part of the United States, there are nine community property states in the United States. Texas, Arizona, New Mexico, California. Utah is not a community property state. Equal ownership of all property acquired during coverture. That means the existence of the marriage. Technically, coverture is the rights that the wife has in the marriage, but it's been generalized in usage in community property states to refer to the time that people are married. So it's during coverture means the time that the marriage is in existence. And under community property law, both parties, the husband and the wife, own an equal share, an undivided 1/2 interest in the property, period. You can convey a deed in community property with right of survivorship today. That's been created. Now we have what are called multi-party ownerships. A joint tenancy is just that what it is. It means they're jointly held. Everybody who's a joint tenant owns a percentage interest in the property. The property could even be equal ownership, or the amount of the joint tenancy percentage can be specified. Some of these can become a nightmare in trying to get the property sold because there are too many joint tenants and you have to track them all down and get them all to agree. However, most joint tenancies are in existence only between a husband and a wife. Then we have something called joint tenancy with right of survivorship, which means that the property passes automatically, instantly upon the death of the first joint tenant, to the remaining joint tenants or tenant. The other one is a tenancy in common, and that is just simply means that everybody owns a piece of the property. That your joint tenancy is an undivided share, meaning that it's a theoretical percentage. Tenancy in common is usually an exact percentage. You own 50% of the property, or you own 20% of the property, or whatever. Types of deeds. First of all, you have warranty deeds that guarantee against defects in title. You have special warranties that only defects that are created during the ownership of the grantor, so they're not guaranteeing that somebody else didn't do something that created a bad title. And a quitclaim deed is the last one, and I've heard so many different ways that people use that. The word quitclaim is a trap. Nobody seems to understand that term. But it basically just says, whatever I own, I'm selling to you, and I'm not guaranteeing that I own anything. So a quitclaim deed is just that. And a disclaimer deed is a deed that says, I have no interest in real property. Because Arizona is a community property state and spouses automatically obtain 50% ownership in the real property, if there was a spouse involved and it was not specifically outlined in the deed, then a lot of times we had to go try to get a disclaimer deed from the spouse saying that she didn't claim any interest in the property, or he didn't. Okay, well, thanks for watching. That's a little bit of an introduction to some of the terminology and some of the concepts and history of law in the United States. This has been a production of BYU Family History Library at Brigham Young University in Provo, Utah. We'd encourage you to watch these videos on our YouTube channel, the BYU Family History Library YouTube channel, where they are posted, and to subscribe if you would like to get notices of new videos as they come out.